Washington, D.C., the present day. The Espionage Act of 1917 is still the law of the land. It has never been amended to include a public interest defense. It has never been updated to distinguish between a spy selling secrets to Moscow and a soldier who mails a document to a journalist. It was written to catch wartime traitors, and it is now used routinely to punish Americans who tell other Americans what their government is doing in their name. Daniel Ellsberg faced 115 years under it. The charges were dropped because the government broke the law trying to destroy him. Frank Serpico was shot in the face and left bleeding on a Brooklyn floor by the colleagues he had tried to expose. Thomas Drake spent 4 years fighting espionage charges for discussing a billion-dollar government failure that the government's own inspectors confirmed was real. John Kiriakou is the only CIA officer who went to prison over the torture program, and he never tortured anyone. This is what happens to the people who tell the truth in America, every single time. Section 1. The weapon they use. The Espionage Act of 1917. Washington, D.C., June 15, 1917. The United States has been at war with Germany for exactly 10 weeks. Congress is moving fast. The country needs laws that can put spies in prison, silence enemy sympathizers, and keep military secrets from reaching Berlin. What they passed that day is called the Espionage Act. Its stated purpose is narrow and specific: stop foreign agents, protect troop movements, prevent sabotage. Nobody in that chamber is talking about journalists. Nobody is talking about government employees. Nobody is talking about a future in which American citizens would use this law against other American citizens who simply told the public what the government was doing in their name. That future arrived anyway. For the first several decades of its existence, the Espionage Act was used sparingly. Between 1945 and 2014, the government used it 11 times to prosecute government workers who had shared classified information with journalists. 11 times across nearly 70 years. That is not a pattern of aggressive enforcement. That is a law sitting in a drawer, pulled out occasionally when the government felt it had no other option. Then Barack Obama became president. 7 of those 11 prosecutions happened on Obama's watch. His administration prosecuted more people under the Espionage Act for leaking to the press than every previous administration in American history combined. The man who ran for office promising the most transparent administration in history ended up using a World War I spy law more aggressively than any president before him, including Richard Nixon, who used it against Daniel Ellsberg and then watched the case collapse in one of the great legal disasters in American political history. That story comes later. What matters right now is understanding the weapon itself, because every person in this episode was hit with it, threatened with it, or had their life destroyed by it. Here is the core problem with the Espionage Act, and it is a problem that has never been fixed. The law was written in 1917. The concept of classified information, the formal system by which the government stamps documents secret and controls who can see them, did not enter the government's official vocabulary until 1951. The Espionage Act is older than the classification system it is now routinely used to enforce. Attorney Jesselyn Radack, who represented multiple whistleblowers charged under the Act, described this plainly. The law was enacted 35 years before the word classification entered the government's lexicon. She concluded that under the Espionage Act, no prosecution of a non-spy could be fair or just. The language of the law makes it almost impossible to defend against. It criminalizes anyone who possesses information relating to the national defense and willfully communicates it to an unauthorized person. Read that sentence again slowly. It does not say the information must be damaging. It does not say the communication must benefit a foreign power. It does not say the person must have intended harm. The only thing it requires is that the information touched on national defense and that someone without clearance received it. Under those terms, a soldier who tells a journalist that his commanding officer ordered a massacre is legally identical to a Russian spy who sells missile codes to Moscow. The law makes no distinction. The jury is never allowed to hear one. Trevor Timm, executive director of the Freedom of the Press Foundation, explained exactly why this matters in court. Basically, any information the whistleblower or source would want to bring up at trial to show that they are not guilty, the jury would never hear. It is almost a certainty that because the law is so broadly written, they would be convicted no matter what. This is not a legal technicality. This is the structural reality of every Espionage Act prosecution. The defendant cannot tell the jury why they did what they did. They cannot argue that the information served the public. They cannot present evidence that no one was harmed. The only available defense is essentially to say, I did not do what they say I did. And because the government controls all the evidence, that defense almost never works. The financial pressure alone destroys people before a single witness is called. Mounting a legal defense against an Espionage Act charge costs between $1 million and $3 million. Most government employees do not have that kind of money. Most of the people charged under this law had to choose between accepting a plea deal, pleading guilty to something, even a lesser charge, just to make it stop, or bankrupting themselves and their families in a trial they were statistically almost certain to lose. That is not justice. That is a financial guillotine suspended over anyone who considers going public. The pattern across administrations is worth sitting with. During the Nixon administration, one whistleblower was charged under the Espionage Act. During Reagan's administration, 1. During both Bush administrations combined, 1. During Obama's 2 terms, 8. During Trump's first term, 5. The acceleration is not subtle. Something changed in the 21st century, and that something was a combination of technology, which made it easier to track exactly who accessed which documents, and political will, which hardened after September 11th into a near total intolerance for any leak that touched on national security, regardless of whether that leak revealed wrongdoing. The September 11th attacks changed the calculation permanently. Before 2001, the general consensus in Washington was that aggressive prosecution of government employees who talked to journalists created more problems than it solved. Trials were public. Evidence was aired. Classified programs got exposed in open court. Better to fire someone quietly, revoke their clearance, and move on. After 2001, that calculation flipped. The intelligence community expanded dramatically. Budgets ballooned. Programs multiplied. The number of people with security clearances grew into the millions. And with that growth came a desperate need to maintain secrecy over operations that were, in some cases, legally and morally indefensible. The Espionage Act became the enforcement mechanism for that secrecy. None of this is to say that every person charged under the Espionage Act was a hero. Some cases were genuinely complicated. Some disclosures did cause real damage. The law exists for legitimate reasons and serves legitimate purposes when applied to actual foreign spies. The problem is that it stopped being applied primarily to foreign spies. It started being applied to Americans who told other Americans what American institutions were doing. Sometimes illegally, sometimes with catastrophic consequences for civilians, sometimes in direct violation of the Constitution. The law gave those institutions a blunt instrument with which to punish the people who exposed them, and those institutions used it. Every whistleblower in this episode faced a version of the same impossible choice. stay silent and remain complicit in something they believed was deeply wrong, or speak and hand the government a law written in 1917 to hunt down wartime traitors, a law with no public interest defense, no motive defense, and legal costs designed to bankrupt anyone who fights back. Most of them spoke anyway, and the government came for them every single time. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. What the Espionage Act did to people in courtrooms was devastating enough. But the story of American whistleblowers does not begin with intelligence agencies or classified documents. It begins on the streets of New York City in the late 1960s, where a police detective spent 5 years trying to report corruption through every legitimate channel available to him, and was shot in the face for his trouble, in different forms and different agencies for the next 50 years. Section 2. Frank Serpico, shot for telling the truth, 1967 to 1972. Frank Serpico joined the New York City Police Department on September 11, 1959. He was 23 years old, a Brooklyn kid who had grown up watching cops patrol his neighborhood, and decided that was what he wanted to do with his life. He served 2 years in the U.S. Army in South Korea first, then put himself through college, and finally got the job he had wanted since childhood. He became a full patrolman on March 5, 1960. He was assigned to the 81st Precinct, worked briefly in the Bureau of Criminal Identification, and was eventually moved to plainclothes work, undercover operations, targeting gambling, narcotics, and vice racketeering in Brooklyn, the Bronx, and Manhattan. He was good at it. He spoke Spanish and could pass convincingly in neighborhoods where other officers could not. He made arrests dressed as a rabbi, a butcher, a bum. He arrested suspects off-duty in other officers' territories because he simply liked catching criminals. He was the kind of cop the NYPD publicly celebrated in recruitment materials and privately found very inconvenient. Because Frank Serpico had a problem, and that problem was that he refused to take money. In the New York City Police Department of the 1960s, this was not a minor personality quirk. It was a structural threat. The corruption Serpico encountered was not a case of a few dishonest officers making bad decisions. It was a system, organized, formalized, and distributed across precincts like a parallel payroll. The Knapp Commission, which would later investigate everything Serpico exposed, identified 2 categories of corrupt cop. Grass eaters were officers who simply accepted the money that police work naturally brought them. Gamblers paid them, drug dealers paid them, pimps paid them, in exchange for being left alone. Meat eaters were the aggressive ones, officers who actively hunted for situations they could exploit for cash. Between the 2 categories, the honest cop was not just the exception. The honest cop was the problem. The way the system worked in plainclothes units was called the pad. Officers on the pad received regular monthly payments, organized by precinct, from the criminal operations they were supposed to be policing. Gambling dens paid between $800 and $1,000 a month per precinct. When Serpico moved into plainclothes and was handed his first envelope, he did not take it. His partner quietly absorbed Serpico's share of the payoff, keeping him out of the system temporarily. But this arrangement could not last. An officer who refused the money was not just personally honest. He was a daily demonstration that the whole operation could be exposed, and the other officers knew it. By 1967, Serpico had enough specific, verifiable evidence of systemic corruption that he began making formal reports. He went to his supervisors. He provided details of 36 separate locations where payoffs to police were occurring. One captain told him directly that if he kept pushing, he would be hauled in front of a grand jury, and by the time the whole thing was over, he would wind up face down in the East River. This was not a metaphor. This was a career officer in the New York City Police Department telling a junior cop that pursuing a corruption complaint could get him killed. Serpico did not stop. He connected with another officer named David Dirk, who had contacts in city government. Together, they took their evidence up the chain to the Department of Investigation, to Jay Kriegel, a senior aide to Mayor John Lindsay. Kriegel told them in 1968 that the administration could not act on corruption charges because it did not want to upset the police during what might be a turbulent summer. In other words, maintaining the political peace with the NYPD was more important than the fact that organized crime was paying the NYPD for protection. Serpico and Dirk kept trying for 3 more years. They went to officials at every level of city government. They found ears that appeared sympathetic, promises that went nowhere, investigations that fizzled, and a wall of institutional silence that proved completely impenetrable from the inside. By February 1970, they were out of options. The only place left to go was the press. On February 12, 1970, Serpico, Dirk, and a lieutenant named Paul DeLeese met with David Burnham, a reporter at the New York Times who covered law enforcement. Burnham already knew from his own reporting that something was badly wrong with the NYPD. What Serpico gave him was the specific, documented evidence to prove it. On April 25, 1970, the New York Times ran a front-page story headlined, "Graft Paid to Police Here, Said to Run into Millions." The story broke the NYPD's internal silence wide open. Mayor Lindsay, who had been told about the problem for years and done nothing, was now forced to act publicly. He appointed a 5-member commission to investigate. Its chairman was a former judge named Whitman Knapp, and it became known simply as the Knapp Commission. Serpico was transferred to narcotics. His colleagues knew he was the source of the Times story. The atmosphere around him became threatening in ways that were impossible to prove, but impossible to ignore. An inspector named Paul DeLeese, who had helped him get to Burnham, told Serpico to be careful, that he could easily be set up. In the months after the Knapp Commission was announced, Serpico's position inside the department became genuinely dangerous. Officers who break the unspoken code among police, the blue wall of silence, have historically not been helped when things go wrong in the field. Serpico was about to find out exactly what that meant. On February 3, 1971, at 10 in the evening, Serpico and 3 other officers from the Brooklyn North Command received a tip that a drug deal was taking place at 778 Driggs Avenue in the Williamsburg section of Brooklyn. The operation was straightforward. Officers Gary Roteman and Arthur Cesar stayed outside. Officer Paul Haley positioned himself at the building entrance. Serpico, because he spoke Spanish, was told to approach the apartment and make contact with the dealer to get the door open. Serpico climbed to the 3rd floor. He knocked on the apartment door. The door opened a few inches. He wedged himself in. What happened next happened fast. The dealer shot Serpico in the face with a .22 caliber pistol at close range. The bullet entered just below his eye and lodged in his jaw. Bullet fragments reached near his brain. The shot severed an auditory nerve, leaving him deaf in one ear for the rest of his life. Serpico fell. He was bleeding heavily from his face on the floor of a 3rd-floor landing in a Brooklyn apartment building. What his backup officers did next is the part that has never been fully explained and has never been formally investigated. None of the 3 officers with him issued a 1013 call, the standard police radio signal meaning "officer down, send help." Not Roteman, not Cesare, not Haley. An elderly man in the neighboring apartment heard the commotion, saw Serpico bleeding on the floor, and called for help himself. It was this civilian, not any of Serpico's fellow officers, who summoned assistance. When a patrol car eventually arrived and the officers realized the man on the floor was Serpico, one of them reportedly said that if he had known it was Serpico, he would have left him there to bleed to death. Serpico was transported to Greenpoint Hospital in a patrol car rather than an ambulance. He survived. Mayor Lindsay visited him in the hospital the following day. The NYPD began hourly bed checks on his hospital room, not to monitor his health, but to monitor who was visiting him. There was no formal investigation into the circumstances of the shooting. Edgar Echeverria, the drug dealer who pulled the trigger, was convicted of attempted murder. The question of why 3 police officers stood by and let a colleague get shot without calling for help, and whether any of them had arranged for it to happen, was never officially examined. Decades later, Serpico was still asking for that investigation. In 2023, he wrote directly to the Manhattan District Attorney requesting a reinvestigation. His attorney cited NYPD internal documents that, in his words, appeared to be concocted in furtherance of discrediting Serpico. The DA's office said it would review the request. As of this writing, no investigation has been opened. 9 months after being shot, in October 1971, Serpico testified before the Knapp Commission. He was still visibly injured. He appeared with his attorney, former U.S. Attorney General Ramsey Clark, before nearly a dozen television cameras. He testified again in December 1971. He was the first police officer in the history of the New York City Police Department to step forward and testify openly about widespread, systematic corruption payoffs amounting to millions of dollars. In his testimony, he described a culture where corruption was, in his words, tolerated, accepted, and encouraged at nearly every level of the department. He told the commission that the problem was not that honest officers could not find a place to complain without fear. They could not complain at all. He said what the hearings needed to produce was a conviction throughout the department that things would actually change, and that without an independent, permanent investigative body, nothing would. On June 15, 1972, Serpico retired from the NYPD. He received the department's highest honor, the Medal of Honor, 1 month before retiring. There was no ceremony. The medal was handed to him across a desk. He later said it was like being tossed a pack of cigarettes. He did not receive the certificate that normally accompanies the medal. He waited 50 years for that certificate. It was finally delivered to him on February 3, 2022, the 51st anniversary of the night he was shot in the face. After retiring, Serpico left the country. He spent years in Switzerland and the Netherlands, then settled for a long period on a farm. He did not return permanently to the United States until roughly a decade later. He still lives in upstate New York. He still carries bullet fragments near his brain. He still suffers chronic pain. He still calls for police reform. He told Rolling Stone magazine in 2020 that an honest cop still cannot find a place to go and complain without fear of recrimination, and that the blue wall of silence will always be there because the system supports it. The Knapp Commission's work did produce changes inside the NYPD. New policies were implemented. Senior personnel were transferred. Hundreds of officers were scrutinized, and some were prosecuted. Michael Armstrong, who served as counsel to the Knapp Commission, observed in 2012 that the attitude throughout the department seemed fundamentally hostile to the kind of systemized graft that had been a way of life 40 years earlier. Serpico disagreed with that assessment. What Serpico's story established, and what made it a template for every whistleblower who came after him, was the precise mechanism of institutional retaliation. You report through internal channels. Nothing happens. You go outside the institution. The institution retaliates. The retaliation is almost never formal or documented. It is a transfer, an isolation, a partner who does not back you up, a 10 to 13 call that never gets made. Then, if you survive it, the institution gives you an award and hands it to you like a pack of cigarettes. The Serpico case involved no classified documents, no federal law, and no courtroom. The weapon used against him was not the Espionage Act. It was something more elemental, the simple withdrawal of the protection that the institution owed him. That pattern repeated itself inside federal agencies for the next 5 decades in more sophisticated and more legally complex forms. Frank Serpico did not have a security clearance. The men who came after him did, and the government used that fact to pursue them far more aggressively. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next person in this story had a security clearance, a top secret one, and used it to access documents that revealed the U.S. government had spent years systematically lying to Congress and to the American public about a war that was killing tens of thousands of people. His name was Daniel Ellsberg, and the Nixon administration's attempt to destroy him set in motion a chain of events that ended a presidency and reshaped American law forever. Section 3. Daniel Ellsberg and the Pentagon Papers, 1971 to 1973. Daniel Ellsberg was not a protester. He was not an outsider. He was one of the most credentialed defense analysts in the United States government, a Harvard-educated economist, a former Marine Corps officer, a Rand Corporation strategist who had spent years at the highest levels of the national security establishment. He had briefed senior Pentagon officials. He had helped advise Henry Kissinger. He had spent 2 years in Vietnam observing military operations firsthand for the State Department. He was, by every measure, an insider. That is what made what he did so devastating to the government that came after him. In 1967, Secretary of Defense Robert McNamara commissioned a study. He wanted to understand, in full documentary detail, how the United States had gotten itself into Vietnam. The decisions made, the intelligence assessed, the options considered and rejected across 4 presidential administrations going back to Harry Truman. He assigned 36 analysts to the task, half of them active military officers, and the other half civilian experts and scholars. The result was a 7,000-page, 47-volume document, classified top secret, completed in late 1968, entitled officially, The Report of the Office of the Secretary of Defense, Vietnam Task Force. Nobody called it that. They called it the Pentagon Papers. Ellsberg was one of the analysts who worked on the study. He was also one of very few people who read the complete document. What he found in those 7,000 pages staggered him. The study documented, with internal government records going back decades, that 4 consecutive presidential administrations had systematically lied, not just to the American public, but to Congress, about nearly every significant aspect of U.S. involvement in Vietnam. The scale of the deception was not incidental. It was structural. President Lyndon Johnson had been secretly sending combat troops to Vietnam while publicly telling voters he had no plans for large-scale military escalation. The Gulf of Tonkin incident, used by Johnson to push Congress into authorizing a massive expansion of the war in 1964, was misrepresented. The internal government assessments consistently showed the war could not be won as resourced, while the public statements said the opposite. Ellsberg began photocopying the documents in October 1969, working nights at an advertising agency in Los Angeles with the help of his former Rand colleague Anthony Russo. It took weeks. The study ran to thousands of pages. He carried pages out of the Rand office in his briefcase past security guards. He and Russo fed them through the copy machine 1 sheet at a time. He was fully aware of what he was doing and what the consequences could be. He later wrote that he believed this course of action would probably put him in prison for the rest of his life, and he did it anyway. For the next 18 months, Ellsberg tried the legitimate channels first. He went to Congress. He approached Senator William Fulbright of Arkansas, chairman of the Senate Foreign Relations Committee, and gave him a copy. Fulbright declined to act. He went to Senator George McGovern of South Dakota. McGovern passed. He went to other members of Congress. None of them were willing to hold hearings or enter the documents into the public record. The study sat. The war continued. American soldiers and Vietnamese civilians kept dying. In February 1971, Ellsberg met with Neil Sheehan, a New York Times reporter who had covered the Vietnam War and whom Ellsberg had first encountered in Saigon years earlier. Ellsberg gave Sheehan access to the documents. Sheehan and his wife quietly copied them and brought the copies to New York. For 2 months, a small team of Times reporters worked through thousands of photocopied pages in a block of rooms at the New York Hilton, while Times editors debated whether publishing classified government documents in the middle of an ongoing war was something they were willing to do. They decided yes. On Sunday, June 13, 1971, the New York Times published the first of what it planned as a series of articles based on the Pentagon Papers. The front page headline read, "Vietnam Archive. Pentagon Study Traces 3 Decades of Growing U.S. Involvement." The following day, Attorney General John Mitchell called the Times and asked them to stop publishing. The Times refused. On June 15th, after the third installment appeared, the Justice Department obtained a federal court injunction forcing the Times to halt publication. It was the first time in the history of the United States that the federal government had gone to court to stop a newspaper from publishing before the fact, what lawyers call prior restraint. The Times appealed. The case moved through the courts with extraordinary speed. Ellsberg was now a fugitive. He spent 13 days evading an FBI manhunt while simultaneously giving copies of the Pentagon Papers to other newspapers. He gave a copy to Ben Bagdikian, the national editor of the Washington Post, meeting him in a Boston motel room. The Post began publishing on June 18th. The Nixon administration immediately sued the Post as well. Then the Boston Globe got a copy. Then the St. Louis Post-Dispatch. Then 15 more newspapers. Every time the government got an injunction against one paper, Ellsberg gave the documents to another. The government took multiple papers to court simultaneously. In total, 19 newspapers eventually published material from the Pentagon Papers. The Supreme Court agreed to hear the case on June 26, 1971. 4 days later, on June 30th, the court ruled 6-3 against the government. The injunctions were unconstitutional prior restraints on the press. The newspapers could publish. Each of the 9 justices wrote separately. The concurrences focused on the absolute centrality of a free press to democracy. Justice Hugo Black wrote that only a free and unrestrained press can effectively expose deception in government. The ruling became one of the landmark First Amendment decisions in American legal history. 2 days before the Supreme Court decided, on June 28th, Ellsberg publicly surrendered to federal authorities at the U.S. Attorney's Office in Boston. He said at the time that he felt that as an American citizen, as a responsible citizen, he could no longer cooperate in concealing this information from the American public, and that he had done what he did at his own jeopardy and was prepared to answer for it. He was charged with conspiracy, espionage, and theft of government property. The charges carried a maximum combined sentence of 115 years in prison. Richard Nixon did not simply want Ellsberg prosecuted, he wanted him destroyed. Nixon and his advisors feared, incorrectly as it turned out, that Ellsberg possessed documents about Nixon's own secret plans for Vietnam, including contingency planning involving nuclear weapons. Henry Kissinger, who had known Ellsberg personally, described him on a recorded White House tape as the most dangerous man in America. A former CIA operative named E. Howard Hunt drafted a formal memo titled Neutralization of Ellsberg, which proposed collecting derogatory information to destroy his public image and credibility. On July 24, 1971, 6 weeks after the Times published its first article, Nixon authorized the creation of a secret White House unit. It was officially called the Special Investigations Unit. Its members called themselves the Plumbers because their job was to plug leaks. The unit was staffed by Eagle Krogh, a deputy assistant to the president, David Young, E. Howard Hunt, and G. Gordon Liddy. Their first major operation targeted Ellsberg directly. The plan was to break into the Beverly Hills office of Ellsberg's psychiatrist, Dr. Lewis Fielding, and steal his patient files. The hope was to find something, anything, in Ellsberg's psychological history that could be used to publicly discredit him. On the night of September 3, 1971, Hunt, Liddy, and a small team broke into Dr. Fielding's office. They used a crowbar to force open the filing cabinet. The file cabinet from that break-in now sits in the Smithsonian Institution's National Museum of American History. The break-in found nothing of use. The plumbers left. The operation was a failure, and what it had produced, a White House-sanctioned burglary of a private citizen's medical records, was so illegal that senior officials immediately began working to conceal it. Ellsberg's trial began in Los Angeles on January 3, 1973. The government's case looked strong. They had him on the documents. The charges were serious. The Espionage Act gave the prosecution enormous structural advantages. But the trial began to unravel in April 1973, when prosecutors informed Judge William Matthew Byrne Jr. that they had learned Howard Hunt had been involved in a break-in at Ellsberg's psychiatrist's office. Then it emerged that the government had also conducted illegal wiretaps on Ellsberg's phone conversations. Then it emerged that the Nixon administration had approached Judge Byrne himself while the trial was ongoing with an offer of the job of FBI director. A sitting federal judge hearing an active criminal case was being offered a prestigious government appointment by the administration prosecuting the defendant before him. Judge Byrne had seen enough. On May 11, 1973, he declared a mistrial and dismissed all charges against Ellsberg and his co-defendant, Anthony Russo. In his ruling, Byrne stated that the totality of the circumstances of this case offend a sense of justice, and that the bizarre events had incurably infected the prosecution. Every charge gone. Ellsberg walked free. The plumbers, however, did not stop with Ellsberg. 9 months after they broke into Dr. Fielding's office in Los Angeles, the same network of operatives, Hunt and Liddy, planned and executed a break-in at the headquarters of the Democratic National Committee at the Watergate complex in Washington, D.C. 5 burglars were arrested there on June 17, 1972. The connection back through Hunt and Liddy to the White House eventually unraveled everything. Nixon resigned the presidency on August 9, 1974. Eagle Krogh, who had authorized the break-in at Fielding's office, pleaded guilty to conspiracy to violate civil rights. He was sentenced to 6 years in prison and served 4.5 months. Hunt and Liddy were convicted for their roles in Watergate and served prison time. The men who ordered the original illegal surveillance of Ellsberg, who authorized the burglary of his doctor's office, who offered a federal judge a job while his trial was in progress, they faced prosecution and prison not for what they did to Ellsberg, but for what they subsequently did to the Democratic Party. The charges against Ellsberg, the man who told the truth, were dismissed. The charges against the men who broke the law trying to destroy him took years to stick, cost a presidency, and sent operatives to prison for crimes committed after the Fielding break-in, not during it. Ellsberg spent the rest of his life as an activist and writer. He was arrested more than 70 times for anti-war and anti-nuclear protests over the following decades. He died on June 16, 2023, at the age of 92. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The Ellsberg case ended with charges dismissed and a presidency collapsed. The next case ended very differently, with a quiet plea deal, a destroyed career, and an NSA official working at an Apple store in a Washington suburb having lost everything for reporting a billion-dollar government failure that the government's own inspectors had confirmed was real. Section 4. Thomas Drake, the NSA insider who lost everything, 2006 to 2011. Thomas Andrews Drake was born in 1957. Before he joined the NSA full-time, he had already spent a decade in the United States Air Force, done a stint as a CIA analyst, and worked as an NSA contractor. He was a decorated veteran with expertise in intelligence technology and linguistics. He started as a full-time NSA senior executive on September 11, 2001. His literal first day on the job was the morning of the worst terrorist attack in American history, and he walked into a building that was about to change the country in ways he found deeply troubling. His trouble began with a choice the NSA made before 9/11 happened. In the late 1990s, the agency faced a basic problem. The internet was generating vast amounts of digital communication, and the NSA needed better tools to sift through it for genuine intelligence. Two competing programs emerged from inside the agency. The first was called ThinThread. It had been built in-house by an NSA mathematician named Bill Binney. It was designed to process enormous amounts of data quickly, identify patterns of communications that might indicate threats, and do all of this in a way that was both cost-effective and constitutionally sound. It included an encryption feature that would hide the identities of American citizens unless a warrant was obtained. ThinThread had been tested in field trials and worked. Its total development cost was approximately $3 million. The second program was called Trailblazer. It was developed by a consortium of outside private contractors, including IBM, SAIC, Boeing, and CSC. It was far more expensive from the start, and its projected costs ran into the billions. Unlike ThinThread, it had not yet been proven to work. And unlike ThinThread, it did not contain built-in protections for the privacy of American citizens. In 2000, NSA Director Michael Hayden chose Trailblazer over ThinThread. ThinThread was canceled. 3 weeks later, 9/11 happened. Drake, now inside the agency full-time, ran information from existing NSA databases through ThinThread after the attacks to test what the system could have done. What he found haunted him. The system identified patterns that contained indications of the September 11th plot months before the attacks occurred. The NSA had possessed fragments of the relevant information, but had lacked the technology to connect them. Drake later described this as the equivalent of an electronic Pearl Harbor, except that the agency had blinded itself. ThinThread, the cheaper, proven, constitutional program, had been shut down and replaced with an expensive program that did not exist yet and would not protect anyone's privacy when it did. That was one problem. The second problem was worse. After 9/11, President George W. Bush secretly authorized the NSA to conduct warrantless surveillance of international phone calls and emails involving people inside the United States. This program bypassed the Foreign Intelligence Surveillance Act, which required court approval for domestic wiretapping. Drake and his colleagues inside the NSA recognized that the agency had taken ThinThread's core data collection code and used it as the basis for a domestic surveillance operation that lacked the privacy protections Binney had built in. The constitutional safeguard had been deliberately stripped out. The NSA was now spying on American citizens without warrants, using technology derived from a program that had originally been designed to prevent exactly that. Drake did what the rulebook said to do. He went through official channels. He raised his concerns with his immediate superiors at the NSA. He testified under subpoena before a House Intelligence Subcommittee in 2001. In September 2002, he served as a major source for a formal complaint filed with the Department of Defense Inspector General by 4 other NSA officials: Bill Binney, Kirk Wiebe, Ed Loomis, and a former House Intelligence Committee staffer named Diane Rourke. The complaint documented the waste, the constitutional violations, and the decision to abandon ThinThread in favor of the far more expensive and less effective Trailblazer. Drake cooperated with the DoD Inspector General investigation for more than 2 years, providing thousands of pages of documents and information. In 2003, the NSA's own Inspector General declared Trailblazer an expensive failure. By 2004, the DoD Inspector General's report, which Drake's cooperation had helped produce, validated the whistleblower's core claims and found very serious flaws at the NSA. The report was classified. It was never released to the public. No one at the NSA was held accountable. The program that had cost over $1 billion and never delivered was quietly buried. The domestic surveillance continued. Drake had now spent years going through every legitimate avenue available to him. He had reported to supervisors. He had testified before Congress. He had cooperated with Inspector General investigations. Nothing had changed. In 2005, he made one more decision. He contacted Shaban Gorman, a reporter at the Baltimore Sun who covered national security. He was careful. He communicated through an encrypted email service. He set a strict ground rule from the beginning. He would not share classified information. He would only discuss what could be documented through unclassified material. Gorman published a series of articles in 2006 and 2007 about waste and mismanagement at the NSA, focusing on the ThinThread and Trailblazer controversy. She named no sources. She won an award from the Society of Professional Journalists for the series. The articles exposed a $1 billion government failure that the government's own internal investigators had already confirmed was real, in a report the public was never allowed to see. In July 2007, armed FBI agents raided the homes of Rourke, Binney, and Wiebe, the same people who had filed the original DoD Inspector General complaint 5 years earlier. Binney later said the agents pointed guns at him and his wife. Wiebe said it reminded him of the Soviet Union. None of these 3 were ever charged with any crime. In November 2007, the FBI raided Drake's home. Agents confiscated his computers, his documents, and his books. At first, Drake cooperated fully. He even gave the agents his computer password. He was questioned repeatedly over the next several months about an alleged leak to the New York Times regarding warrantless wiretapping. Drake told investigators he had not spoken to the Times. He said he had provided unclassified information about Trailblazer to the Baltimore Sun. The investigation continued for years without charges being filed. In the meantime, Drake's career collapsed. He had been reassigned in 2006 to the National Defense University, where he served as an NSA chair and assistant professor. When his security clearance was suspended in 2007, he was forced out. He resigned from the NSA in April 2008. He took a teaching position at Strayer University. He was fired from that job after his indictment. In April 2010, a federal grand jury in Baltimore indicted Drake on 10 felony counts. 5 counts were under the Espionage Act, charging him with willful retention of national defense information, meaning he had kept documents at home. The remaining counts were obstruction of justice and making false statements to federal investigators. If convicted on all charges, he faced up to 35 years in prison. The specific documents at the center of the Espionage Act charges became one of the most embarrassing aspects of the prosecution as the case developed. Drake's lawyers, public defenders Deborah Boardman and James Wida, produced at a pre-trial hearing in March 2011 one of the documents described in the indictment as classified. It was stamped unclassified. Judge Richard D. Bennett looked at the government attorneys and asked them directly whether their position was that, despite the document being stamped unclassified, it still related to national defense and could support an Espionage Act charge. The government said yes. One of the documents had actually been declassified by the NSA after the indictment was filed, meaning it had been classified specifically for the purpose of charging Drake with possessing it. The government also argued in its pre-trial filings that it had no legal obligation to prove Drake intended to harm national security. Under the specific provision of the Espionage Act they were using, the prosecution only needed to show he possessed documents relating to national defense. What he intended, why he kept them, and whether any damage resulted were legally irrelevant. Judge Bennett also ruled, before the trial began, that the government would be required to present certain classified evidence in open court rather than through summaries, meaning the government would have to actually show the jury the material it was using to prosecute Drake. The NSA concluded that showing the jury the real evidence would damage national security. So prosecutors withdrew key documents from evidence, restricted others, and made a calculation. They could not go to trial with what they had left. In early June 2011, days before the trial was scheduled to begin, and shortly after a 60 Minutes broadcast on May 22nd that gave Drake his first major public platform to tell his story, the government collapsed its entire case. All 10 felony counts were dropped. In exchange, Drake pleaded guilty to a single misdemeanor, exceeding authorized use of a government computer. He paid no fine, he received 1 year of probation and 240 hours of community service. At the July 15, 2011 sentencing hearing, Judge Bennett did not stay quiet. He told the court it was unconscionable to charge a defendant 2 years after his home had been searched, with a list of serious crimes that could have resulted in 35 years in prison, only to drop all 10 counts of the indictment on the eve of trial. He described his irritation with the prosecution openly and rejected the government's request for a $50,000 fine. Drake was 54 years old. He had no criminal record for the previous 4 years of investigation. His security clearance was gone. His NSA career was over. He had been fired from his university teaching position as a direct consequence of the indictment. He had been driven into debt. At the time the case was most actively in the news, he was working at an Apple store in downtown Bethesda, Maryland, answering customer questions about consumer electronics. The government's public explanation for the prosecution was that it had been brought on the merits and nothing else. A Justice Department spokesman stated that whistleblowers are the key to many department investigations, and that the government did not retaliate against them. Drake told 60 Minutes that he understood exactly why he had been charged the way he had: to send a message to other employees inside the NSA and other intelligence agencies. Do not speak up. Do not go to the press. Do not tell truth to power. We will hammer you. The government later conceded through subsequent litigation that the journalist's articles had not relied on any of the allegedly classified information found in Drake's house. The DoD Inspector General report that Drake had helped produce, the one that confirmed his core claims, remained classified and was never released publicly. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The Drake case showed what happened when a government employee followed every rule, went through every proper channel, and still ended up facing 35 years in prison for telling journalists about a program the government's own inspectors had confirmed was a failure. The next case involved a man who also wore his country's uniform, also followed internal channels, also found them useless, and ended up not in an Apple store, but in a military prison for 7 years, convicted for sharing nearly 750,000 documents that showed the world what the United States Army was actually doing in Iraq and Afghanistan. Section 5. John Kiriakou, the only CIA officer jailed over torture, 2007 to 2015. John Kiriakou joined the CIA in 1990, 14 months after his first interview with the agency. He was the son of Greek-American parents raised in Newcastle, Pennsylvania, and had studied Middle Eastern affairs and legislative politics at George Washington University. He began as an analyst specializing in Iraq, was posted to Bahrain as an economic officer, then transferred to the CIA's Directorate of Operations, where he recruited foreign agents, ran counterintelligence operations in Athens, and was nearly assassinated by Greek leftist militants. By September 11, 2001, he was chief of counterterrorist operations in Pakistan, one of the most active postings in the agency at the worst possible moment in American history. On the night of March 28, 2002, Kiriakou led the CIA team that captured Abu Zubaydah in a raid on a safe house in Faisalabad, Pakistan. Zubaydah was then believed to be al-Qaeda's third-ranking official, and his capture was treated as a major intelligence victory. Kiriakou sat with Zubaydah for days after the raid. He did not witness what happened next. CIA officials offered to train Kiriakou in what the agency called enhanced interrogation techniques. He refused. What happened to Zubaydah in CIA custody became one of the most consequential and most contested facts in the entire post-9/11 debate about American power. The CIA waterboarded Abu Zubaydah 83 times. The interrogations were secretly recorded on videotape. In 2005, despite a judicial order to preserve evidence, the CIA destroyed those videotapes. The agency internally distributed disinformation about how many times Zubaydah had been waterboarded, suggesting the number was far lower. The Senate Intelligence Committee's later investigation found that the useful intelligence gathered from Zubaydah was obtained before the waterboarding began, not as a result of it, and that the CIA had misrepresented the effectiveness of the program to Congress and the public. In 2004, Kiriakou left the CIA after 14 years. He went to work in the private sector, consulted on intelligence matters, served as a senior investigator for the Senate Foreign Relations Committee, and advised Committee Chairman Senator John Kerry. In 2007, he agreed to give an interview to ABC News journalist Brian Ross. What he said in that interview on December 10, 2007, changed everything. Kiriakou told Ross that waterboarding had been used on Abu Zubaydah. He said the authorization for the technique had come directly from the White House. He said that when he'd been told about the waterboarding, he had believed it was necessary at the time, but that he had changed his mind. Waterboarding was torture, he told ABC News, and it was something the United States should not be doing. Because Americans, he said, were better than that. He was the first United States government official to publicly confirm that waterboarding had been used as official CIA policy on al-Qaeda detainees. Within 24 hours of the broadcast, the CIA filed a crimes report against him with the Department of Justice. The DOJ rejected it. Then filed 5 more similar reports about Kiriakou as the months went on. The DOJ rejected all of them. The formal investigation against Kiriakou did not begin with his public comments about waterboarding. It began in 2009 when investigators discovered that detainees held at Guantanamo Bay possessed photographs of CIA and FBI personnel who had interrogated them. The investigation traced that leak through a chain of communications and eventually led to Kyriakou. What they found was this. In 2008, Kyriakou had exchanged emails with a freelance writer who claimed to be working on a book about CIA rendition practices. In those emails, Kyriakou confirmed the name of a former CIA colleague who had been involved in the detention and interrogation program. That colleague was still, technically, an undercover officer at the time. The freelance writer passed the name to lawyers representing Guantanamo detainees. The name appeared in a sealed legal filing. It was not made public. The name eventually appeared on the New York Times website in October 2011, but not as a result of anything Kyriakou had done after the initial disclosure. In a separate 2008 incident, Kyriakou gave a New York Times reporter the business card of a CIA agent named Deuce Martinez, who had worked for a private government contractor with known involvement in the interrogation program. Martinez had never been an undercover agent. His contact information and his past CIA affiliation were already publicly available on the internet at the time Kyriakou shared the card. On January 23, 2012, Kyriakou was charged with 5 felony counts: 3 counts under the Espionage Act, 1 count under the Intelligence Identities Protection Act of 1982, and 1 count of making false statements to the CIA's Publications Review Board by allegedly lying about his own book during the mandatory pre-publication review process. The full charges carried a potential sentence of up to 45 years in prison and over $1 million in fines. The Intelligence Identities Protection Act had been passed in 1982, largely as a response to a series of incidents in which CIA officers' covers had been blown. In the 30 years between its passage and Kyriakou's case, it had produced exactly 1 successful prosecution: Sharon Scranage, a CIA secretary who in 1985 gave the names of other agents to her boyfriend in Ghana. Kyriakou's prosecution became his 6th criminal case filed by the Obama administration against a government employee accused of mishandling classified information, twice as many as all previous administrations combined. He initially pleaded not guilty to all charges and was released on bail. For months, he prepared for a trial that could send him to prison for most of the rest of his working life. Then came the comparison that stopped many people in the national security community. Scooter Libby was Vice President Dick Cheney's chief of staff. In 2003, he was involved in leaking the identity of Valerie Plame, an active undercover CIA officer, to the press. A leak that was widely understood as political retaliation against her husband, who had publicly contradicted the Bush administration's claims about Iraq's weapons program. The leak ended Plame's career and compromised the network of CIA contacts built around her cover identity. Libby was convicted in 2007 of 2 counts of perjury, 1 count of obstruction of justice, and 1 count of making false statements. He was sentenced to 30 months in prison. President George W. Bush commuted his sentence before he served a single day. Libby paid a fine and served 2 years of supervised release. Kyriakou disclosed the name of a former CIA officer to a freelance writer who never published it. The name appeared in a sealed legal document. He faced up to 45 years. Libby exposed an active covert officer to the press as a political weapon, and the president who authorized the underlying Iraq intelligence deception wiped his sentence away. Bruce Riedel, a former senior CIA analyst who had been Kyriakou's boss at the agency and who turned down the directorship of the CIA in 2009, was asked by the New York Times about Kyriakou's situation. The irony, Riedel said, was very simply that Kyriakou was going to be the only CIA officer to go to jail over torture, even though he had publicly denounced it. It was deeply ironic, Rydell said, under the Democratic president who ended torture. On October 23, 2012, Kyriakou accepted a plea deal. He did not want to face the Espionage Act charges in a courtroom he knew he could not win in. He did not want to spend 45 years separated from his wife and 5 children. He pleaded guilty to 1 count of violating the Intelligence Identities Protection Act for revealing the undercover officer's name in his email exchange with the freelance writer. All 3 Espionage Act counts were dropped. The false statements count was dropped. He was the second person ever convicted under the Intelligence Identities Protection Act in its 30-year history. On January 25, 2013, federal judge Leonie Brinkema sentenced Kyriakou to 30 months in prison. At sentencing, she said the case was not a case about a whistleblower, but about a man who had betrayed a solemn trust. She said 30 months was frankly too light because the message had to be sent to every covert agent that leaving the agency did not give you the right to start revealing the names of people with whom you worked. At the same hearing, she noted that the 30-month sentence was identical to the sentence Scooter Libby received, the man whose sentence was erased before he spent a single night in custody. Kyriakou reported to the Federal Correctional Institution in Loretto, Pennsylvania, on February 28, 2013. From inside, he wrote a series of letters published under the title Letters from Loretto, describing prison life and continuing to make the case publicly that his prosecution was punishment for exposing torture, not for administrative disclosure violations. On February 9, 2015, after serving nearly 23 months of his 30-month sentence, he was released. When CIA Director David Petraeus sent a memo to agency employees after Kyriakou's conviction, he described it as an important victory for the agency, the intelligence community, and the country, and said that oaths do matter and that there are consequences for those who believe they are above the laws that protect fellow officers. Petraeus himself was later investigated for providing classified information to his biographer, with whom he was having an affair, and pleaded guilty in 2015 to a misdemeanor charge of unauthorized removal and retention of classified material. He was sentenced to 2 years of probation and a $100,000 fine. He served no prison time. The CIA officials who waterboarded detainees were never charged. The officials who destroyed the videotapes of the waterboarding sessions, despite a judicial order to preserve them, were never charged. The lawyers who wrote the legal memos authorizing the torture program were never charged. The one CIA official who told the American public that the program existed and that it was wrong spent 23 months in a federal prison in Pennsylvania. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. While Kyriakou was the first CIA officer to go to prison in connection with the torture program, he was not the last intelligence community employee to pay an enormous price under the Obama administration's prosecution surge. The next case involved a young Army intelligence analyst sitting in a forward operating base in Iraq, watching footage of American helicopters killing civilians and journalists, and deciding that the public had a right to know what was being done in their name. Section 6. Chelsea Manning, the heaviest sentence in history, 2010 to 2017. Chelsea Manning was born in Crescent, Oklahoma on December 17, 1987. Her parents divorced when she was 13. Her mother took her to Wales for a period, and she returned to the United States in 2005 to live with her father in Oklahoma City. She worked briefly at a software company, demonstrated a talent for computers, but struggled to hold steady employment. In October 2007, at age 19, she joined the U.S. Army. She later said that the benefits under the GI Bill for college were part of her motivation. After completing basic training in April 2008, she attended intelligence school at Fort Huachuca in Arizona. She graduated in August 2008 with a top-secret security clearance and was assigned as an intelligence analyst to the 2nd Brigade, 10th Mountain Division at Fort Drum, New York. In October 2009, she deployed to Iraq and was stationed at a forward operating base east of Baghdad. Her job gave her access to classified military databases containing reports on both the Iraq and Afghanistan wars, diplomatic cables from the State Department, and a range of other sensitive government material. She was 22 years old, sitting in a forward operating base in a combat zone, with access to some of the most sensitive information the U.S. government possessed. And what she found in those databases, she later described as deeply disturbing. The documents showed a picture of both wars that was substantially different from what was being reported publicly. The Iraq war logs contained detailed accounts of Iraqi civilian deaths. One diplomatic cable documented that U.S. troops had executed at least 10 Iraqi civilians, including a woman in her 70s and a 5-month-old infant, in the town of Ashaki in 2006, then called in an airstrike to destroy the evidence of the killings. The document showed the military had logged over 15,000 civilian deaths in Iraq and Afghanistan that had never been publicly reported. They showed systematic failures to investigate detainee abuse and torture. They showed the gap between what officials said in press conferences and what was being recorded in the classified internal record. Then Manning found the video. In a judge advocate's directory on the classified network, she found footage from an Apache helicopter gunship. It was filmed on July 12, 2007, above the Al-Amin al-Thaniya district of Baghdad. The footage showed the crew of the helicopter firing on a group of approximately 10 men on the ground. 2 of the men were Reuters journalists, photographer Namir Noor Eldin, 22 years old, and driver Saeed Chamag, 40 years old. Neither was armed. The crew, apparently misidentifying cameras as weapons, received permission to open fire. Noor Eldin, Chamag, and several others were killed in the first burst of fire. A van pulled up minutes later with 2 children inside, driven by a man who stopped to help the wounded. The helicopter crew fired on the van. The driver was killed. Both children were seriously wounded. The crew members were heard on the audio laughing and encouraging each other. The U.S. military had investigated the incident, concluded the soldiers acted within the rules of engagement, and did not reveal to Reuters how their journalists had died. Reuters had been seeking the video through Freedom of Information requests since 2007. Those requests had been denied. Manning passed the video to WikiLeaks on or around February 21, 2010. Before that, she had already uploaded the Iraq and Afghan war logs on February 3rd. She attempted to interest the Washington Post and the New York Times in the material before going to WikiLeaks. The Washington Post reporter did not appear interested. The New York Times did not return her call. In late March 2010, she sent WikiLeaks a video of the May 2009 Grenai airstrike in Afghanistan. She also downloaded and transmitted 251,287 U.S. diplomatic cables and 482,832 Army field reports covering the wars in Iraq and Afghanistan. The total came to nearly 750,000 documents and was the largest unauthorized disclosure of classified material in U.S. history to that point. She described her own motivation in a statement at her trial. She said she began to become depressed by the military situation in Iraq and Afghanistan while on leave in January 2010, and felt that if the public had access to the information she had seen, it could spark a domestic debate on the role of the military and on foreign policy in general. She was caught because she told someone. In May 2010, she began an online conversation with Adrian Lamo, a former hacker who had become a journalist and security consultant. In those conversations, she told Lamo she was the source of the material WikiLeaks had been releasing. Lamo went to the Army's Criminal Investigation Command within days. Manning was arrested on May 27, 2010, at her forward operating base in Iraq. WikiLeaks published the collateral murder video on April 5, 2010, 6 weeks before her arrest, and while she was still in Iraq. The footage was watched by millions of people around the world. It generated immediate global news coverage and a fierce debate about what American forces were actually doing in Iraq. Reuters confirmed that Noor al-Din and Shama were their employees and called for a full investigation. After her arrest, Manning was transferred to Camp Arifjan in Kuwait, where she was held for 2 months in what her supporters described as a cage inside a tent, in temperatures reaching 105 degrees Fahrenheit. She was moved to the Marine Corps base at Quantico, Virginia, on July 29, 2010, where she was classified as maximum custody and placed on prevention of injury status. What happened to Manning at Quantico over the following 9 months became the subject of formal international condemnation. She was confined to her cell for approximately 23 hours per day. She was regularly stripped naked, including being required to stand naked for morning inspection. She was denied her reading glasses, which meant she could not read. She was prohibited from sleeping during daylight hours. All visits, including those with her lawyer and family, were non-contact, and she was shackled at the wrists and legs during them. She was denied meaningful exercise and social interaction. In January 2011, after an altercation with guards, the Quantico Brig commander placed Manning on suicide watch, had her clothing and eyeglasses removed, and required her to remain in her cell 24 hours a day. Her lawyer said Manning had joked to the guards that if she wanted to harm herself, she could do it with her underwear or flip-flops. State Department spokesman Philip Crowley publicly described her treatment as ridiculous, counterproductive, and stupid. Obama responded by saying the Pentagon had assured him her treatment met basic standards. Crowley resigned 3 days after making his comments. Almost 300 legal academics, most of them law professors, signed an open letter describing her pre-trial treatment as degrading and inhumane. In March 2012, Juan Mendez, the United Nations Special Rapporteur on Torture, formally ruled that the US government's treatment of Manning was cruel, inhuman, and degrading. The Pentagon refused to allow Mendez to meet with her directly. Manning was transferred from Quantico to the medium-security military prison at Fort Leavenworth, Kansas, in April 2011, after 9 months. She was charged with 22 offenses. The most serious was aiding the enemy, a capital offense, though prosecutors stated they would not seek the death penalty. She was also charged with multiple counts under the Espionage Act. The court-martial began in June 2013. Manning was not permitted to present a public interest defense. The judge ruled before trial that Manning could not argue her disclosures served the public good, that they revealed genuine wrongdoing, or that no actual harm to national security had been demonstrated. The jury in an Espionage Act case does not hear those arguments. They were not legally relevant. On July 30, 2013, Manning was found guilty of 20 of the 22 charges. She was acquitted of the single most serious charge, aiding the enemy. On August 21, 2013, she was sentenced to 35 years in prison. Her rank was reduced to Private E1. she was dishonorably discharged. The 35-year sentence was the longest ever handed down in American history for providing information to the media. The ACLU described it as almost 20 times the pre-Obama record for such a case. Military prosecutors had asked for 60 years. The maximum possible sentence on all convicted charges was 90 years. The day after sentencing, Manning publicly announced she was a transgender woman and would be seeking hormone therapy during incarceration. The military initially refused, stating it did not provide hormone therapy or sex reassignment surgery for gender identity disorder. After Manning filed a federal lawsuit in 2014, the military approved hormone replacement therapy in February 2015. She remained in an all-male military prison throughout. On July 5, 2016, Manning was taken to a hospital after a suicide attempt. The military charged her with offenses related to the attempt and sentenced her to 14 days in solitary confinement with 7 days suspended. She was not permitted legal representation at the disciplinary hearing. On October 4, 2016, she attempted suicide again while still serving the solitary sentence from the first attempt. In November 2016, Manning filed a formal clemency petition asking Obama to commute her sentence to the 6 years she had already served. On January 17, 2017, 3 days before leaving office, Obama commuted all but 4 months of her remaining sentence. He said publicly that her 35-year sentence was very disproportionate relative to what other leakers had received, and that she had served a significant amount of time. He described it as a commutation, not a pardon, meaning her conviction stood. On May 17, 2017, Manning was released from Fort Leavenworth after 7 years of confinement. The crime she exposed, the Baghdad helicopter killings, the 15,000 unreported civilian deaths, the Ishaqi executions, were never prosecuted. No soldier faced criminal charges over the collateral murder video. The cover-up of the Ishaqi killings was not formally investigated as a result of the disclosure. The only person who went to prison over any of it was the 22-year-old analyst who decided the public had a right to know. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Manning leaked documents that numbered in the hundreds of thousands. The next whistleblower in this story leaked a single page, one document printed and folded, carried out of a secure NSA facility tucked into her clothing. That single page landed reality winner in federal prison with the longest sentence ever given to a journalist source in American history. Section 7. Edward Snowden, exiled for telling the truth, 2013 to present. Edward Joseph Snowden was born on June 21, 1983, in Elizabeth City, North Carolina. His family moved to the Maryland suburbs near NSA headquarters at Fort Meade when he was a child. His father served in the Coast Guard. His mother worked at the U.S. District Court in Baltimore. He dropped out of high school during his sophomore year after contracting mononucleosis and never returned, instead earning a GED and taking intermittent computer classes at community college. In May 2004, he enlisted in the Army Reserve as a Special Forces candidate and was discharged 4 months later. He then worked as a security guard at a covert NSA facility at the University of Maryland. By 2006, Snowden had talked his way into a job at the CIA, working in information technology security. In 2007, he was posted undercover to Geneva, Switzerland, managing computer network security for the agency. In 2009, disillusioned with what he described as a dangerous CIA recruitment practice he witnessed in Switzerland, he left the agency and moved into private contracting, first for Dell, then later Booz Allen Hamilton, both of which held major NSA contracts. Through those companies, he worked at NSA facilities in Japan, Maryland, and finally Hawaii, where Dell assigned him in March 2012 as lead technologist for the NSA's Information Sharing Office. In Hawaii, Snowden's access to classified material was extraordinarily broad. He was working at the NSA's Regional Operations Center, whose focus was electronic monitoring of China and North Korea. He could view and download virtually everything the agency held, except its absolute highest-level programs. What he found as he worked deeper into the NSA's infrastructure was a picture of domestic and global surveillance that he believed was both illegal and unconstitutional, and that the American public had no idea existed. On March 12, 2013, Director of National Intelligence James Clapper testified before the Senate Intelligence Committee. Senator Ron Wyden of Oregon asked him directly, "Does the NSA collect any type of data at all on millions or hundreds of millions of Americans?" Clapper said no. That was not true, and Clapper later admitted it. He told NBC News in 2014 that he had responded in what he thought was the most truthful or least untruthful manner by saying no. Wyden's office had sent the question to Clapper the day before the hearing so he could prepare a response. He gave a false answer anyway. Snowden later said in a television interview from Moscow that the decisive moment for him was seeing Clapper directly lie under oath to Congress. That moment, he said, meant there was no going back. In March 2013, Snowden moved from Dell to Booz Allen Hamilton, taking a new contractor position at the same Hawaii NSA facility. He later said he took the job deliberately, specifically because it gave him broader access to the documents he had decided to collect. On December 1st, 2012, he had already reached out to journalist Glenn Greenwald under a pseudonym. In January 2013, he contacted documentary filmmaker Laura Poitras. He also communicated with Barton Gellman of The Washington Post. All communications were conducted using heavy encryption. He told each of them he had information about NSA programs that the public had a right to see. On May 20th, 2013, Snowden told his NSA supervisor he needed medical leave to manage his recently diagnosed epilepsy. He boarded a commercial flight from Hawaii to Hong Kong. He told his girlfriend, Lindsay Mills, that he would be away for a few weeks without explaining why. When she found out, he was already gone. On June 5, 2013, The Guardian published the first story based on Snowden's documents. It revealed a top-secret foreign intelligence surveillance court order requiring Verizon to hand over, on a daily and ongoing basis, call records for all of its U.S. customers. Not suspected terrorists, not people under investigation, but every single Verizon subscriber in the country. The order required Verizon to provide to the NSA the numbers involved in every call, the duration of every call, the location data, and unique identifying information for all communications, both domestic and international. It had been operating secretly under a court order that no member of the public had ever seen. On June 6th, The Guardian and The Washington Post published simultaneous stories revealing PRISM, a data collection program that gave the NSA court-approved direct access to the servers of 9 of the largest American internet companies, including Google, Facebook, Apple, Microsoft, and Yahoo. The program allowed the NSA to collect search histories, email content, file transfers, and live chats. PRISM was described in NSA internal documents as the #1 source of raw intelligence used in NSA analytic reports. On June 9th, Snowden identified himself publicly in a video interview with The Guardian. He said he had no intention of hiding because he had done nothing wrong. On June 14, 2013, the U.S. Justice Department charged Snowden with 2 counts of violating the Espionage Act of 1917, unauthorized communication of national defense information, and willful communication of classified communications intelligence to an unauthorized person, as well as theft of government property. The State Department revoked his passport the same week, stranding him. Snowden had intended to travel from Hong Kong through Moscow to Ecuador, where he planned to seek asylum. His passport was canceled while he was in transit through Moscow's Sheremetyevo International Airport. Russian authorities restricted him to the airport's transit zone. He spent 40 days in that transit area, not in Russia proper, not in any country, while his lawyers negotiated asylum applications with dozens of nations. He was denied by 27 countries. On August 1, 2013, Russia granted him temporary asylum for 1 year. On August 7, 2014, Russia gave him a 3-year residency permit. In October 2020, Russia granted him permanent residency. In November 2020, Snowden announced he and Lindsay Mills, who had joined him in Moscow and whom he married in September 2019, were applying for Russian citizenship while intending to retain their American nationality. What Snowden's documents revealed kept generating legal and legislative consequences long after the initial publications. In January 2014, the Privacy and Civil Liberties Oversight Board, a federal government body, concluded that the NSA's bulk telephone metadata collection program lacked a viable legal foundation under the statute cited to authorize it, implicated constitutional concerns under both the First and Fourth Amendments, raised serious threats to privacy and civil liberties, and had shown only limited value in counterterrorism. The same panel found no evidence that the bulk phone data collection had stopped any terrorist attack. In May 2015, the U.S. Court of Appeals for the Second Circuit ruled in the ACLU's lawsuit against James Clapper that the NSA's mass telephone metadata collection program was not authorized by Section 215 of the Patriot Act and was therefore illegal. The program that Clapper had told Congress did not exist, that Snowden had revealed did exist, was found by a federal appeals court to have been operating outside the law. On June 2, 2015, President Obama signed the USA Freedom Act into law. For the first time since 1978, a piece of legislation restricted rather than expanded the surveillance authority of the U.S. intelligence community. The law prohibited the NSA from continuing its bulk collection of American phone records. The Guardian and the Washington Post received the Pulitzer Prize for Public Service in April 2014 for their reporting on Snowden's documents. In September 2019, Snowden published a memoir titled Permanent Record. On the same day it was published, the U.S. Justice Department sued him to recover all earnings from the book, claiming he had violated his non-disclosure agreements with the CIA and NSA by not submitting the manuscript for pre-publication review. A federal court ruled in Snowden's favor on some aspects and in the government's favor on others, ultimately directing the book's proceeds related to the contractual violations into a government trust. James Clapper, the Director of National Intelligence, who told Congress under oath that the NSA did not collect data on millions of Americans, was never charged with any crime. He apologized to the Senate Intelligence Committee in July 2013, saying his response had been clearly erroneous. He resigned in November 2016 at the end of Obama's term. CNN hired him as a national security analyst in August 2017. Snowden remains in Russia, charged with 2 counts of violating the Espionage Act, facing up to 30 years in prison if he ever returns to the United States. He told NPR in a 2019 interview that he believed the NSA's mass surveillance programs would not have withstood a constitutional challenge, and that the American public deserved a chance to see these issues determined by open courts. The courts, and eventually Congress, agreed with him. He is still in exile. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. While Snowden is the most globally recognizable whistleblower of the surveillance era, his case was followed closely by a woman whose story received far less international attention, but whose treatment by the American justice system was in several respects even more severe. Reality Winner was 25 years old, working at a small NSA contractor facility in Augusta, Georgia, and she leaked a single document about Russian election interference. The government made sure her punishment was impossible to ignore. Section 8. Calling Raleigh, the FBI agent who warned them. 2002. Calling Raleigh grew up in New Hampton, Iowa, graduating as valedictorian of her high school class in 1973. Her father was a letter carrier for 31 years. She earned a degree in French from Wartburg College in Waverly, Iowa, and then a law degree from the University of Iowa. In 5th grade, she had written a letter to FBI headquarters asking about the agency and received back a booklet called 100 Facts About the FBI. From that point on, she had one career in mind. She joined the FBI as a special agent in January 1981. Over the next 2 decades, she worked in Omaha, Jackson, Mississippi, the FBI's New York office, where she handled organized crime cases and wiretap applications, the U.S. Embassy in Paris as an assistant legal attaché, and the U.S. consulate in Montreal. In 1990, she was transferred to the Minneapolis field office, where she eventually became Chief Division Counsel, the top legal officer for the division. In that role, she taught constitutional law and law enforcement ethics to FBI agents and other law enforcement officers. She had spent 20 years building her career inside the institution she had wanted to be part of since she was 10 years old. On August 13, 2001, 29 days before September 11th, flight instructors at a Pan Am International Flight Academy in Eagan, Minnesota, contacted the Minneapolis FBI office. They had a student they were concerned about. His name was Zacharias Moussaoui, a French-Moroccan citizen who had paid $8,000 in cash for lessons to fly a Boeing 747 flight simulator. He did not want to learn takeoffs or landings. He wanted to learn to steer a large commercial aircraft in flight. The instructors found his focus strange and his demeanor alarming. Raleigh's colleagues in Minneapolis arrested Moussaoui for overstaying his visa, which gave them legal grounds to hold him. They then began investigating his background and reached out to French intelligence. What came back was significant. French intelligence confirmed that Moussaoui was connected to radical fundamentalist Islamic groups and had been placed on a watch list as a suspected terrorist. He had traveled repeatedly to Afghanistan and Pakistan. The Minneapolis agents believed they had clear grounds to seek a Foreign Intelligence Surveillance Act warrant to search Moussaoui's laptop computer and personal effects. Under FISA rules at the time, they needed to prove the suspect was an agent of a terrorist group or a foreign government. They believed the French intelligence information met that standard. They went to FBI headquarters in Washington for authorization. Headquarters said no. The supervisory special agent at FBI headquarters who reviewed the request decided the evidence was insufficient. He sent back questions that Raleigh later described in her memo as almost ridiculous. Bureaucratic objections that, in her view, demonstrated a fundamental failure to understand the threat Moussaoui posed. The Minneapolis agents rewrote their request and sent it back. It was rejected again. Throughout August 2001, they kept trying. Headquarters kept blocking them. One Minneapolis agent became so frustrated that he told a supervisor the Minneapolis office was trying to make sure that Moussaoui did not take control of a plane and fly it into the World Trade Center. That warning, documented in the 9/11 Commission's eventual findings, was not acted upon. When Rowley's colleagues later searched the laptop, after September 11th, after the warrant issue was moot, they found files on crop dusting and commercial flight simulations. The attacks happened on September 11th, 2001. Rowley watched them from Minneapolis along with the rest of the country. Within days, she was recounting what her office had tried to do to other FBI personnel from different divisions. Almost everyone's first reaction, she later wrote, was to ask why FBI headquarters would deliberately sabotage a case. 3 days after the attacks, FBI Director Robert Mueller stated publicly that the agency had no inkling the hijackers had trained at American flight schools. Rowley and the Minneapolis agents, who had spent all of August trying to get authorization to investigate a man who had paid cash to train on a 747 simulator and whose terrorist connections had been confirmed by French intelligence, heard Mueller say that and were speechless. Then a second piece of information emerged. An FBI agent in Phoenix, Arizona, had written a memo on July 10, 2001, warning FBI headquarters that an unusual number of Middle Eastern men were attending American flight schools and suggesting a possible connection to al-Qaeda. That memo, addressed to the head of the FBI's radical fundamentalist unit at headquarters, had been buried. The Phoenix memo and the Moussaoui investigation had both landed on the desk of the same supervisor at headquarters. Neither had been acted upon. Neither had been connected to each other. Rowley and her Minneapolis colleagues became so frustrated by Mueller's public statements that they began attaching copies of their original August memo about Moussaoui to every single document they sent to Washington as a form of silent protest. In May 2002, Rowley was asked to come to Washington to meet with members of a congressional committee in a closed session. Unable to sleep the night before, she started writing down what she needed to say. The writing did not stop. Over several hours, she produced a 13-page memo addressed directly to FBI Director Mueller. It detailed, point by point, and with documented specifics, how FBI headquarters had systematically blocked the Minneapolis office from investigating Moussaoui in the weeks before September 11th. She described the roadblocks thrown up by headquarters as happening almost inexplicably. She accused headquarters of operating with a double standard that protected senior officials from accountability while field agents faced harsh scrutiny for far lesser mistakes. She noted specifically that the supervisory special agent who had blocked the Moussaoui warrant was promoted after September 11th. On May 21, 2002, she sent the memo to Mueller and hand-delivered copies to 2 members of the Senate Intelligence Committee. The FBI immediately classified it. A few days later, it was leaked to the press anyway. The contents of the memo became front-page news across the country. Mueller's public claim that the FBI had no warning before September 11th was now directly contradicted by the FBI's own senior lawyer in Minneapolis, writing in a documented 13-page internal memo with specific names, dates, and events. The political pressure was immediate. Mueller was called before Congress. The Senate Judiciary Committee held hearings. Rowley testified publicly in June 2002, telling the committee about the FBI's internal culture of bureaucratic risk aversion its broken computer systems, its failure to share information across divisions, and the institutional protection of senior officials who made catastrophic errors. Her memo eventually led to a 2-year investigation by the Department of Justice Inspector General. Mueller was pushed to undertake a significant reorganization of the FBI, including the creation of a new Office of Intelligence. In December 2002, Time magazine named Rowley its Person of the Year, alongside Sharon Watkins of Enron and Cynthia Cooper of WorldCom, 3 women who had each risked their careers to report serious institutional failures. Rowley occupied the center of the magazine's cover. The professional consequences arrived quietly but clearly. After a year of national attention, Rowley went back to being a regular field agent. In April 2003, she stepped down from her GS-14 Chief Division Counsel position to return to a GS-13 Special Agent role. The timing coincided with her second major act of public dissent. In February 2003, with the Bush administration building its case for the invasion of Iraq, Rowley wrote Mueller a second open letter. She told him directly that the FBI would not be able to stem the flood of terrorism that would likely come in the wake of an attack on Iraq. She argued that invading Iraq would bring an exponential increase in the terrorist threat to the United States, both at home and abroad. She noted that Mueller himself had testified to the Senate that the al-Qaeda network remained the most immediate and serious threat facing the country, and that a U.S.-Iraq war could push Baghdad to more directly engage al-Qaeda, but that Mueller had not connected those dots publicly. The letter was published in the New York Times. Mueller did not respond to it. Rowley retired from the FBI on December 31, 2004, 11 days after turning 50, when she became eligible for a full pension. She had served for 24 years. In February 2005, a majority of Minnesota's congressional delegation nominated her to serve on the newly created Privacy and Civil Liberties Oversight Board, a federal body established by the 9/11 Commission's reform legislation specifically to ensure counterterrorism investigations did not violate civil liberties. The Bush administration did not select her. In 2006, she ran for Congress in Minnesota's 2nd District as a Democratic farmer-labor candidate against Republican incumbent John Klein, a retired Marine Corps colonel. She campaigned on FBI reform, civil liberties, and opposition to the Iraq War. Klein's campaign raised roughly twice what Rowley's campaign raised. Klein won with 55.9% of the vote to Rowley's 44.1%. The supervisor who blocked the Moussaoui warrant at headquarters, the official whose decisions Rowley documented in her 2002 memo, was never formally disciplined. No FBI headquarters official faced an Office of Professional Responsibility investigation over the pre-September 11th failures. The DoD Inspector General investigation, triggered by Rowley's memo, concluded after 2 years. No one was fired. No one was demoted. Rowley had documented with specific names and dates a chain of decisions that she argued had left the country vulnerable to the worst terrorist attack on American soil in history. The institution gave a supervisor a promotion and named Rowley Person of the Year. Rowley's case is different from every other whistleblower in this episode in one important way. She was never prosecuted, never charged, never threatened with the Espionage Act. The government's response to her was not legal punishment, but institutional marginalization, a quiet demotion, a nominations board that did not select her, a congressional race she lost for lack of funding. The pattern of retaliation was real and measurable. It just happened without a courtroom. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The FBI agent who warned them about the pre-9/11 failures paid with her career but kept her freedom. The next whistleblower in this series had no such luck. She was 25 years old, had served in the Air Force, and leaked one document about Russian interference in the 2016 election. She received a longer federal prison sentence for leaking to the media than anyone in American history. Section 9. Reality Winner, the longest sentence ever, 2017 to 2021. Reality Lee Winner was born on December 4, 1991, in Kingsville, Texas. She grew up speaking some Arabic at home, developed a talent for languages as a teenager, and enlisted in the United States Air Force in December 2010 at the age of 19. The Air Force trained her as a cryptologic language analyst, someone who listens to, translates, and analyzes intercepted communications in foreign languages. She became fluent in Dari, Farsi, and Pashto, the languages of Afghanistan and Iran. She was assigned to the 94th Intelligence Squadron at Fort Meade, Maryland, and as part of that work, she used her language skills to support the drone program, identifying targets, confirming enemy combatants, and assisting pilots in the targeting process. She served for 6 years. When she was discharged in December 2016, she had received the Air Force Commendation Medal and had been credited with aiding in 650 enemy captures, 600 enemies killed in action, and the identification of 900 high-value targets. She was 25 years old and had spent 6 years doing classified work in the most sensitive operations the United States military conducts. She left the Air Force and moved to Augusta, Georgia. She taught CrossFit, she worked at a yoga studio, she applied for jobs with NGOs in Afghanistan because she wanted to use her language skills for humanitarian work. But her lack of a college degree made it difficult to get those positions. On February 13, 2017, less than 2 months into Donald Trump's presidency, she began working for Pluribus International Corporation, a defense contractor assigned to an NSA facility at Fort Gordon near Augusta. Her job was to translate documents related to Iran's aerospace program from Persian. She held a top-secret security clearance. She had been at the job for less than 4 months when she came across the document she decided to mail to the press. The document was a 5-page NSA intelligence report dated May 5, 2017. It described in specific operational detail how Russian military intelligence, the GRU, had conducted a cyber attack against a Florida-based company called VR Systems, which supplied voter registration software and electronic poll books to election officials in several states, including Florida, North Carolina, and others. According to the NSA report, Russian hackers had first breached VR Systems in August 2016, using spear phishing emails disguised as Google alerts sent to company employees. After gaining access to VR Systems' internal systems, the GRU then used that access to send a second wave of malicious emails to more than 100 local election officials across the country in late October and early November 2016, the final days before the election. The emails appeared to come from VR Systems and contained Microsoft Word attachments embedded with malware, designed to give hackers complete remote control of the infected computers. The Trump administration and its allies had spent months insisting that Russian interference in the 2016 election was a hoax or grossly overstated. The document Winner held showed it was neither. More specifically, it showed the Russian operation had directly targeted the infrastructure used to register voters and run polling places in multiple states, information that state election officials had not been given and that the federal government was not rushing to share with them. Winner printed the document on May 9, 2017. She folded it and tucked it into her pantyhose when she left the secure facility. She mailed it from Augusta to the New York newsroom of The Intercept, the same publication that had published Edward Snowden's documents and Chelsea Manning's material, with no note and no identifying information about herself. She had no idea how color laser printers work. Every color laser printer manufactured and sold in the United States since at least the mid-2000s prints a pattern of nearly invisible yellow dots on every single page it produces. These dots are microscopic, arranged in a grid, and encode the printer's serial number, model number, and the precise date and time the document was printed. The dots are there because the United States Secret Service struck a deal with printer manufacturers to help catch counterfeiters. They can be used for other purposes. Winner printed the NSA document at 12:28 p.m. on May 9, 2017. Those dots recorded every detail of that fact on the pages she then folded and mailed. The Intercept received the document and decided to verify it with the NSA before publishing. On May 30, 2017, the Intercept contacted the NSA and sent the agency a copy of the document to confirm its authenticity. The NSA examined the copy and immediately noticed that the pages were folded and creased, which meant someone had printed the document physically and carried it out of a secure space rather than transmitting a digital file. This was not a digital leak from someone using an encrypted file transfer. This was a piece of paper that had been in someone's hands. The NSA ran an internal audit and determined that 6 employees had accessed the specific document on its classified system. Of those 6, only 1 had made contact with the Intercept using a personal email account from her work computer. On June 3, 2017, the FBI obtained a warrant and went to Winner's home in Augusta. Armed agents surrounded her as she returned from a grocery run. Her mother, Billie Winner Davis, later said that Winner told her she was very scared and had not expected any of this. During the interview with FBI agents at her home, Winner admitted that she had printed the document and mailed it to the news outlet. She said she knew it was not authorized and knew the contents could be used to the advantage of a foreign nation. Winner Davis later said her daughter felt she was going to disappear and that agents were asking her questions in a way that made her feel she had no choice but to comply. Winner did not have a lawyer present during that interview. The Department of Justice announced her arrest on June 5, 2017, the same day The Intercept published its story about the document. Winner had already been in custody for 2 days before the article went live. She was 25 years old. She was denied bail twice and held at the Lincoln County Jail in Lincolnton, Georgia, for more than a year before her case was resolved. The document she leaked, the story The Intercept published, landed with immediate national impact. The day after publication, the U.S. Election Assistance Commission sent a bulletin to state officials across the country warning about the specific security vulnerabilities the document described. Multiple state and local election officials told reporters they had heard nothing from federal agencies about this specific Russian operation before reading about it in the press. The Senate Intelligence Committee's bipartisan investigation later found that many state election officials had first learned about Russian attempts to penetrate their systems from press coverage, not from the federal government. The committee found that federal warnings to the states had been limited in substance and distribution, and that states had not understood the scope or seriousness of the threat they were facing. The same GRU operation described in Winner's leaked document was later included in Special Counsel Robert Mueller's July 2018 indictment of 12 Russian military intelligence officers. Winner pleaded guilty in June 2018 to a single count of transmitting national defense information in violation of the Espionage Act. She had no option to argue that her disclosure served the public interest. The Espionage Act does not allow that defense. a motion by her lawyers to allow testimony from state election officials who said they had been grateful and alarmed to learn from her leak what was happening to their systems was denied by the federal judge. The evidence that her disclosure had helped protect American elections was legally irrelevant. On August 23, 2018, she was sentenced to 63 months, 5 years and 3 months in federal prison. Prosecutors described the sentence at the time as the longest ever imposed in federal court for an unauthorized release of government information to the media. Winner was transferred to the Federal Medical Center, Carswell, in Fort Worth, Texas, where she could receive treatment for her bulimia and be relatively close to her family in Texas. The day after sentencing, President Trump tweeted that the sentence was small potatoes compared to what Hillary Clinton had done and called it very unfair. Winner, calling in by phone from jail, told CBS News she could not thank him enough. Her legal team filed a formal petition for commutation with the Department of Justice in February 2020. Trump did not grant it. A federal judge rejected Winner's request in April 2020 to be released to home confinement due to the COVID-19 pandemic, despite her lawyer's documented arguments that her bulimia and respiratory issues made her significantly more vulnerable to serious illness than a typical inmate. She remained at Carswell. The Intercept's editor-in-chief issued a public statement after sentencing acknowledging shortcomings in the outlet's handling of the document. Multiple security experts noted that the publication's decision to send a physical copy of the printed document directly to the NSA for verification had handed the government a roadmap to the source. The outlet had essentially helped identify its own source to the agency that would prosecute her. On June 2, 2021, Winner was released to a residential reentry facility, a transitional halfway house, after earning early release credits for exemplary behavior during her incarceration. Her lawyer confirmed the release was not the product of a pardon or any clemency process, but of time earned through good conduct. Winner had served approximately 3 years and 9 months of her 63-month sentence. She was 29 years old. The sentence she received for leaking one document about a foreign government's attack on the American election system was longer than any sentence previously given to any journalist source in the history of the United States federal courts. James Clapper, who told Congress the NSA was not collecting data on millions of Americans when it was, never faced charges. David Petraeus, who gave classified notebooks to his mistress and biographer, received 2 years of probation. Reality Winner mailed one document to a news outlet and spent nearly 4 years in federal prison. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The final whistleblower in this series also leaked material related to a government program that killed civilians and was never supposed to be public. Daniel Hale was a former Air Force intelligence analyst who revealed the hidden mechanics of America's drone assassination program, specifically how the military counted the people it killed. His sentence and the conditions of his imprisonment represented the government's final statement on what it does to people who tell the public the truth about war. Section 10. Daniel Hale, jailed for exposing the drone wars, 2019 to 2024. Daniel Everett Hale was born on August 1, 1987. He grew up in a rural mountain community in Tennessee. By his own account, he had a difficult early adulthood. He experienced periods of homelessness and financial instability. He was opposed to militarism by the time he was old enough to think seriously about it. He knew what he thought about war. Then he joined the Air Force anyway, because in 2009 he had nowhere else to go and the military offered stability, structure, and a paycheck. He enlisted in July 2009 and was trained as an intelligence analyst. The Air Force sent him to work with the National Security Agency. In 2013, he was assigned to the Joint Special Operations Task Force at Bagram Air Base in Afghanistan. the largest U.S. military base in the country. His job was to identify, track, and target people for drone strikes. He used signals intelligence to locate suspects, monitor their movements, and help build the cases that would put names on kill lists. He was 25 years old, working in a trailer at an airbase in Afghanistan, watching the coordinates of human beings on screens and helping determine which ones would die. He later wrote in a handwritten letter to the court that throughout his service he was troubled by the uncertainty of whether anyone he was involved in killing or capturing was a civilian. There was no way of knowing, he wrote. He watched children inadvertently killed in airstrikes. He came to believe the drone program had little to do with preventing terrorism from reaching the United States, and much more to do with protecting the profits of defense contractors. In 2013, Hale attended an anti-war conference in Washington, D.C. A man from Yemen stood up and recounted through tears that 2 of his family members had been killed in a U.S. drone strike. The man said his relatives had been trying to encourage young men to leave al-Qaeda. They were not fighters. Hale realized, sitting in that room, that he had watched the fatal strike from Bagram. He and his colleagues had classified it as a success. He left the Air Force in July 2013 and was honorably discharged. A defense contractor offered him a job working for the National Geospatial Intelligence Agency as a political geography analyst, adding data to government maps of China. He took it because the money was more than he had ever made. At the NGA, his co-workers socialized after work by watching videos of drone strikes. Hale had spent his Air Force years doing the targeting work. Watching it as entertainment after what he had seen in Afghanistan pushed him into a crisis that he described as a decisive break from any remaining ambivalence about what he needed to do. He had already begun communicating with investigative journalist Jeremy Scahill of The Intercept in April 2013, while still in the Air Force. Between February and August 2014, while working at the NGA, he used his classified work computer to print 36 documents. 23 of those documents had nothing to do with his assigned work mapping Chinese geography. He provided 17 of those documents to Scahill. 11 of the 17 were marked either secret or top secret. What those documents showed was the detailed internal architecture of the American drone assassination program, the actual mechanics of how it worked, who made the decisions, how targets were selected, and what happened to the people who were not the intended targets. The documents detailed a special operations campaign in northeastern Afghanistan called Operation Haymaker. Between January 2012 and February 2013, U.S. Special Operations airstrikes killed more than 200 people during that operation. Of those killed, only 35 were the intended targets. During one 5-month period within that operation, close to 90% of the people killed in airstrikes were not the people the military had been trying to kill. The documents further revealed how the U.S. military classified every single person killed in a drone strike as an enemy killed in action, unless proven otherwise after the fact. This meant that civilians killed in strikes were systematically counted as combatants in the official record. The program that the Obama administration had publicly described as precise and surgical, designed to minimize civilian casualties, the documents showed it was doing the exact opposite, and the military was actively concealing the true casualty count through its classification system. The documents also contained details of the secret watch list system, the rules and procedures the government used to place people on no-fly lists and terrorism suspect lists, without those people ever being told they were listed, charged with any crime, or given any opportunity to challenge their designation. The Intercept published the material in October 2015 as a multi-part investigation called The Drone Papers. It was the first time the internal workings of the American drone assassination program had been documented in detail from primary sources. In the aftermath of the publication, the Obama administration in 2016 introduced new requirements for public reporting of civilian casualties from drone strikes and other covert operations, directly acknowledging, under sustained pressure, that 64 to 116 civilians had been killed in such operations that year. The program had previously denied causing significant civilian casualties. The FBI raided Hale's home in August 2014. He was not charged at that point. He continued living in Nashville, Tennessee, working as a dishwasher, appearing in a documentary film about drone program whistleblowers called National Bird, and speaking publicly at conferences about the drone war and its human cost. The FBI investigation continued quietly for years. In May 2019, 5 years after the home raid, Hale was arrested in Tennessee and charged in federal court in Virginia with 5 counts, 4 under the Espionage Act and 1 for theft of government property. The charges carried a maximum combined sentence of 50 years. He pleaded not guilty and was released on bail. In March 2021, facing the near certainty of conviction that the Espionage Act structure guarantees, no public interest defense, no motive defense, no way to tell a jury why he did it, Hale pleaded guilty to 1 count of retaining and transmitting national defense information. The remaining 4 counts were dropped. Before sentencing, Hale submitted an 11-page handwritten letter to the court. He opened it with a quotation from U.S. Navy Admiral Jean LaRocque. "We now kill people without ever seeing them, and since it is done by remote control, there is no remorse, and then we come home in triumph." Hale then described in detail his time in Afghanistan, the strikes he had participated in, the Yemeni man at the conference who had described his family members' deaths, and the moment he decided he could not stay silent. He wrote that he believed it was wrong to kill, but that it was especially wrong to kill the defenseless. He told the court he was grief-stricken and ashamed of himself. He also told the court he had revealed what was necessary to dispel the lie that drone warfare keeps Americans safe and that American lives are worth more than the lives of those the drones kill. At the sentencing hearing on July 27, 2021, the courtroom was packed with supporters. Federal Judge Liam O'Grady sentenced Hale to 45 months in prison. Prosecutors had asked for 9 to 11 years. Before announcing the sentence, O'Grady said something that received wide attention. He told Hale directly that he was not being prosecuted for speaking out about the drone program killing innocent people, and that Hale could have been a whistleblower without taking any of these documents. In court, Hale responded by noting he was a descendant of Nathan Hale, the American Revolutionary spy executed by the British in 1776, and paraphrased his ancestors' reported last words: "I have but this one life to give in service of my country." U.S. Marshals took him away. People in the packed gallery stood and waved goodbye. What happened next to Hale in the federal prison system became its own story. He was initially transferred to Northern Neck Regional Jail in Virginia. In early October 2021, the Bureau of Prisons moved him to the United States Penitentiary in Marion, Illinois, and placed him in a communications management unit. CMUs are the most restrictive units in the federal prison system, short of solitary confinement. They were originally created to house people convicted of terrorism offenses. Hale was placed in one for leaking documents to a journalist. He was believed to be the first person convicted for an unauthorized disclosure of information to the press to be imprisoned in a CMU. In a CMU, inmates receive very limited access to visitors. Hale was allowed 2 15-minute phone calls per week. All calls were monitored. All mail was read. Contact with the outside world was reduced to the minimum the federal system was legally required to provide. The Center for Constitutional Rights described being sent to a CMU as uniquely stigmatizing because the facilities are publicly described as terrorist units. U.S. Representative Ilhan Omar wrote to President Biden in August 2021 requesting a full pardon or commutation for Hale, stating his disclosures had shown a vital light on the legal and moral problems of the drone program. Biden did not respond to the request. No pardon was granted. In March 2024, Hale reached home confinement. On July 5, 2024, he was fully released after serving 33 of his 45 months. He had spent most of his incarceration in a unit reserved for terrorists for telling journalists that the U.S. drone program was killing 9 civilians for every intended target during a 5-month period in Afghanistan, and that the military was counting those civilians as enemy combatants in its official records. In October 2024, Hale received the inaugural Ellsberg Whistleblower Award, named for Daniel Ellsberg, the Pentagon Papers whistleblower who had died the previous year at age 92. Ellsberg had personally chosen Hale to be the first recipient of the award before he died. Hale accepted it. The pilots who flew the strikes that killed the civilians were never charged. The officials who designed the classification system that disguised those deaths as enemy combatants were never charged. The people who built the drone program's targeting infrastructure and publicly misrepresented its precision were never charged. The one man who documented what the program was actually doing and gave those documents to a journalist spent nearly 3 years in a terrorism unit in a federal prison in Illinois. 10 people, 10 different stories, but a single pattern running through all of them from 1971 to 2024. A government that uses an antiquated wartime spy law to silence the people who tell its citizens the truth, while the officials whose decisions those citizens most needed to know about face no consequences at all. The final section draws that thread together and states plainly what the accumulated evidence of this entire episode means. If you enjoyed this video, make sure to subscribe. Thanks for watching, and I'll see you in the next one.